Hello, everyone. My name is Giovanni Nogales, and I am a paralegal here at Laos Parker. Thank you for joining us for this new webinar series with the Home Care Association of Louisiana. Today's webinar is entitled Buying and Selling Home Health and Hospice Agencies. Our presenters today are Jennifer Papapanagiotou and Lester Johnson. Jennifer focuses on compliance, regulatory, and transactional matters for a wide array of healthcare providers, including home health and hospice agencies. She has extensive experience in analyzing proposed and existing businesses arrangements for compliance with federal and state fraud and abuse laws and drafting a wider variety of legal agreements. Ms. Papapanagiotou is knowledgeable in all aspects of state licensing for home health and hospice providers, and in Medicare, Medicaid enrollment, including initial enrollment, changes of ownership, and appeals of revocation actions. Finally, she assists clients with compliance, forming new businesses, and addressing Medicare and Medicaid program coverage and reimbursement issues. As for Lester, he is a partner at Laos Parker and is the supervising attorney for the firm's Baton Rouge office. In addition, Les also serves as a co-leader of the firm's health law practice group. Les helps clients navigate the myriad of regulatory, compliance, and business issues facing today's healthcare providers and practitioners. Core areas of Les' practice includes handling Medicare and Medicaid appeals, Medicare and Medicaid participation, and compliance. This is just a quick reminder. If you have any questions throughout the presentation, please feel free to type them in the chat box, and we will address as many as possible at the end of the presentation. So without further ado, I present to you your speakers, Lester Johnson and Jennifer Papapanagiotou.
Hi, thank you, Gio. This is Jennifer, and I have Lester on the other end of this lovely webinar with me. Les is in or around, Lester, you're in Monroe area now, right?
I am currently, yeah.
Yeah.
I'm all over the place.
Yeah. So, and I'm in Houston, Texas, and do a lot of work in the Texas, Louisiana markets. And we're going to talk today a little bit about buying and selling home health agencies. This is a presentation we do for a lot of organizations, and you know, we appreciate everybody who's dialed in to listen. We have a pretty small group today, so please, if you guys have questions as we go along, feel free to type them in the chat box. We'll try to get to as many as we can. Gio, let's go ahead and go to the next slide. Do you hear me, Gio?
Yeah. Do you know how to do the table of contents?
I don't see anything but the title slide right now. All right, there we go. All right, so today we'll talk a little bit about what we're seeing as far as mergers and acquisition trends. We're going to cover some basics of transactions, talk a little bit about applicable health laws, and then run through at a high level important steps and documents, typical post-closing issues, and some of the special considerations for home health and hospice deals that are kind of unique to healthcare. Let's go to the next slide. As far as trends, these are just sort of a laundry list of observations that I'm seeing in that come up repeatedly in transactions that I work on, and I do a ton of work on both the buy side and the sell side. Pandemic-related enforcement is continuing to be an issue, and it's something we have to consider in every transaction, whether I'm representing a seller or a buyer. That includes sort of the laundry list of what was available during COVID. PPP loans, the HRSA provider relief funds, which were grant monies given to organizations. They're the automatic grants that happened for certain providers in April of 2020, and then there were optional rounds you could participate in. And while these were grants, they did require certain reporting, and if you didn't do the reporting timely, you can't have liability associated to repay that money back. SBA disaster loans were also available to providers, and I have seen several transactions where we've had to deal with those because it's not easy to sell an organization that has one of those loans without entirely paying it back. And there are other sort of smaller programs that were available that we look at as well, like Medicare advance payment. There is a program going on right now and has been in effect for a while now that allows CMS and the CMS contractors to do what they call enhanced oversight for hospices in certain states that undergo true changes of ownership. Obviously, Louisiana is not on this list, but I always include it when I talk to folks because I understand sometimes people own organizations that are not necessarily in their home state. So in Arizona, California, Nevada, and Texas, if you have a true change of ownership, which is what we call an asset sale, where the owner, after the transaction is completed, is a new entity with a new EIN and a new NPI number typically, that takes assignment of the Medicare agreement usually, or you have 100% change in equity owners, you'll be subjected to this enhanced oversight after the transaction closes. This is an active program, and we're seeing a variety of ways that it's being used. Specifically, it involves prepayment review of claims after the transaction closes and you report your change of ownership. If you get involved in something like this, I highly, highly, highly recommend you get counsel or a good consultant involved to help you through that process, because it's a little bit like TPE, where they review a selection of claims, and if you have an error rate over a certain percentage, then they can kick you into another round of review or enhance that review or refer you for further review to something like a UPIC. And it can result in enforcement activity like revocation of provider numbers if things don't go well. So it's important that you put your best foot forward on that one. I'm sure everybody is probably familiar, or maybe not, with CMS's what we call 36-month rule. This has applied to home health agency transactions for many, many years, and it prevents you from being able to sell a home health agency or to have what they call a change in majority ownership more often than every 36 months. This rule was extended to hospices effective January 1 of last year, 2024. And it is something we have to look at in every single transaction we consider. You got to get a very detailed ownership history and make sure this isn't going to be an issue, or look at ways you can structure around it if it is an issue. Obviously, integrity auditing by UPICs and SMRCs and other sort of organizations is still very, very active, and it's especially active these days in hospice for whatever reason. And just as a sort of transactional observation, it used to be, probably pre-COVID time, that patient census was really a key metric that drove pricing in transactions, and I'm seeing that less and less. They're really more interested in EBITDA. The sophistication of financial analysis being done in transactions has really ramped up. And it does depend somewhat on the size of an agency, what they find most helpful in pricing a transaction, but really I'm seeing largely purchase prices being driven by EBITDA. Let's go to the next slide. Some things to just know about transactions overall. First and foremost, it seems like every month I get a phone call from somebody who says, I either want to buy or sell my home health agency, and I'd like to close by the end of the month. Realistically, that's difficult. And healthcare transactions, because they involve regulatory review and approval, depending on the kind of transaction, just take longer. They often involve a lot of contracts, payer agreements, vendor agreements that need some kind of communication before you can close a transaction to ensure those agreements stay in place. It's just very, very typical that healthcare transactions that involve agencies generally need a little time to get completed correctly and to really do appropriate thorough due diligence and to serve and receive consents where required before you can close. So I would say typical transactions usually take somewhere between 60 days and 4 or 5 months. It can be shorter in some situations. It can be longer in some situations. It really depends on the parties involved. We are seeing smaller operators sell. A lot of private equity consolidation is still going on, although I will say it seems to have slowed a little bit since the frantic 2020, 2021 time period, where during COVID, it was insanely busy with private equity, which just sort of flush with money. Interest rates were low. and they were out there buying anything and everything they could find at really crazy multiples. But we're still seeing pretty, and in fact, in the last, I'd say 12 months, I've seen a real uptick in the volume of deals. We always suggest to any seller, any buyer, you need a lawyer to do a transaction. And I will say even more specifically, you need a transactional lawyer that knows something about healthcare or will leverage a regulatory attorney to help them. Your average run-of-the-mill guy who buys and sells real estate or buys and sells other non-healthcare businesses is not going to be familiar with the regulatory things that are important in a healthcare transaction. They could certainly partner with somebody who does know those things, but it's important because you can overlook some important stuff in a transaction if you don't have that healthcare context or experience. We also think it's important for both sides to have good accounting and valuation and tax expertise to help them through the process and to advise them. Let's go to the next slide. The first bullet is it sounds really simple, but this applies to buyers and sellers. You know, do your homework on the other side and don't be afraid to walk away from a deal if it doesn't feel right to you. I know that sounds very, very simple, but it is, you know, your instincts in any given situation are important. And I've certainly had buyers and sellers who've gotten well into due diligence, even exchanging purchase documents, and something just isn't right. Either the negotiations over some point are not proceeding the way that one party wants them to, and they're not comfortable with the terms, or something comes up in diligence that just is a bigger issue than anybody anticipated. And so it you know, deals all the time, they come and they go, and we always want them to get to closing, but there can be any number of reasons why one side or the other doesn't want to proceed. And, you know, short of having signed a purchase agreement, generally the parties can part ways amicably. Many deals get to that letter of intent stage but never get any further because something happens, and that sort of goes along, you know, second bullet, first bullet kind of go together. Every deal is different, and, you know, an attorney who does transactional work will probably tell you like 70 to 80% of a transactional document, whether it's an asset purchase or an equity purchase, is going to be pretty much the same from deal to deal. In healthcare, about 20 to 30% of that document is going to be very specialized to healthcare and the very particular things we worry about in healthcare, liabilities and whatnot, and the regulatory process. So let's go to the next slide. So important steps and documents. These are sort of the heavy hitters, is sort of the process that we follow when we're doing transactions. First and foremost, a letter of intent. While letters of intent are technically optional, you don't have to have a letter of intent, I will say I encourage them. The reason being, it is the first and best opportunity for buyer and seller to get on the same page about expectations. And, you know, if a buyer is writing a letter of intent after having looked at a potential business, there are going to be things they don't know yet, and both sides need to acknowledge that. But they're putting down on paper, this is what I think your business is worth and what I'm willing to pay you for it, and here's sort of the general terms that are important to me. And it's a good opportunity to stimulate conversation between buyer and seller about expectations. And what's important for both parties, once you've written it down in that LOI, while a lot of it isn't going to be binding, it is going to, like I said, set expectations for both sides about what the eventual purchase agreement is going to include. There are parts of the letter of intent that are binding and should be, things like confidentiality and exclusivity, sort of a no-shop clause that sort of locks the parties into talking to each other for a certain period of time so the seller can't negotiate with someone else. And those are important. And obviously confidentiality also becomes a very important element if you don't have a separate NDA or confidentiality agreement that you've entered into already. So I like letters of intent because they kind of get everybody's cards on the table early and help work through some of the more important terms early. Next step, generally after you've signed an LOI, is for the buyer to begin their due diligence. They'll send usually a lengthy list of questions to the seller and request lots and lots of documents and lots of information about the business. Those are important it's a really important process for both sides, because it's where the seller is going to tell the buyer everything they want to know about the agency, but they're also going to disclose all of the challenges that may exist. If there are liabilities, if there are loans, if there are regulatory reviews going on. Buyers aren't necessarily going to be scared off by those disclosures, but if they aren't brought up and aren't disclosed in this process, it can become a really big problem later on and create a lot of liability for the seller. So due diligence is, you don't want to shortcut it. You don't want to skip steps. You want to be sure you go through that process pretty methodically. We'll talk more about each of these as we go through here. So once you've gotten pretty far into due diligence, usually the buyer's side is going to draft a purchase agreement and lay down in very specific detail all of the terms of the transaction. It's going to cover purchase price and things like a holdback escrow or any kind of post-closing payments. It's going to include what are called representations and warranties, which are facts that the seller usually largely represents are true about the organization. It's also going to highlight and list out what we call schedules, any exceptions to those representations and warranties. So you might make a rep and warranty about there's no lawsuits filed against the company and the company owns all its assets free and clear of any liens. That's what representations and warranties look like. It's also going to address indemnifications. So that's each party promising to make the other party whole for certain things or certain liabilities that may come up. It's going to talk about exceptions and limitations to those indemnifications, and then it's going to usually refer to some ancillary closing documents that get signed at the time you close the deal. And then finally, you're going to move to closing, which is when legal ownership of the business actually changes hands. Let's go to the next slide. So these are just some highlights before you draft and sign a letter of intent or a purchase agreement. Discuss the deal you're contemplating with an attorney. I'm going to say this over and over again. I really like to see folks get an attorney involved at the letter of intent stage. It just helps you issue spot, make sure your letter of agreement, your letter of intent is thorough. You really do need an attorney to help you with the purchase agreement. I have dealt with way too many situations where parties went out and found some document on the internet and tried to paper a deal with that agreement. And it just can create havoc after the fact. If something goes wrong in the transaction or things weren't done correctly, it can create regulatory problems, and it certainly can create liability issues between the parties if something comes up after closing where one side thinks the other side owes them money, and this purchase agreement maybe doesn't do a great job of laying out who's responsible for what. You should keep in mind that federal and sometimes state law can impact terms and timing of a healthcare transaction. That can be regulatory, that can be any host of issues that are really specific to healthcare. An attorney can help you understand limitations in purchase price, financing, notice periods, and other key terms. Again, a healthcare attorney will be able to help you navigate that. And just keep in mind, and we're going to talk about this a little bit more, if a buyer is going to pay a seller over time, or there's going to be any kind of significant post-closing payments, the healthcare fraud and abuse laws can sometimes affect how that's structured. Again, we're going to cover that actually next. So let's go to the next slide. So the two big laws we worry about most of the time, and there are certainly others, but these are the two sort of heavy hitters we worry about, are the Stark Law and the Federal Anti-Kickback Statute. Stark Law is a civil statute, and it really only applies in sort of very limited circumstances. And for transactional reasons, it's really not a big issue in most transactions. But briefly, the Stark Law prohibits a physician, first of all, from referring patients for designated health services. That's a defined term. Only certain things are designated health services, to an entity with which the physician or his immediate family has a financial relationship, unless an exception applies. And the reason we mention this is because home health services are designated health services under the Stark Law. The good thing about this is that Stark would only apply if your home health agency has a physician owner, and that physician will ever refer Medicare patients to the home health agency after the deal closes. So that's a pretty rare set of circumstances, frankly, because there's such a limited set of circumstances where a physician can ever be an owner of a home health agency. Stark pretty much prohibits that unless you're in a rural area and you meet a whole bunch of other criteria. So I just don't see a lot of physician owners in home health. I don't want to spend an overly large amount of time on Stark for that reason, but I will just say that if you are dealing with a seller who has any kind of physician ownership and it's a home health agency, you need to get a healthcare attorney involved. Let's go to the next slide. There's a way to structure around this, but I don't want to go into a lot of detail. We're going to talk about on the next slide. Gio, let's go ahead and go to the next one. We're going to talk about the anti-kickback statute. So this is a federal criminal law that prohibits the knowing and willful exchange of anything of value to induce or arrange for referrals payable by Medicare or Medicaid. Violation of it, like I said, it's a criminal law, so there can be significant penalties and, obviously jail time associated with it. Transactions among parties who may refer to each other after closing are subject to the anti-kickback statute. This comes into play very importantly where you have earnouts. So an earnout is usually a payment that happens after closing that is somehow tied to the financial performance of the agency after closing, usually. So it becomes really important where a seller is going to keep working with the buyer, especially after closing. And that's not uncommon. Not every deal is structured that way. A lot of times sellers are, they've owned an agency for a long time. They want to sell it and they want to retire. Okay, great. Then we don't worry about the anti-kickback statute. We don't worry about earnouts so much. But I've worked on deals where sellers are not going into retirement. They want to go work for the buyer. It's a big private equity company, and that company is really interested in having that owner continue on with them. And deals that involve earnouts, you've got really specific things you have to worry about and ways you have to structure to avoid anti-kickback statute problems. Let's go to the next slide. And certainly not every deal involves an earnout, and oftentimes we actively try to avoid them in situations where you are going to have a seller stay on after closing. But there is a safe harbor. Safe harbors are regulatory provisions that outline specific arrangements that if you meet every single element of a safe harbor, your particular financial arrangement will not violate the anti-kickback statute. The problem is we don't really have a safe harbor that applies to home health or hospice transactions. There is one that was drafted many, many years ago in the 90s that applied to sales of medical practices. And it specifically protected transactions among healthcare providers who were usually licensed physicians and between physicians and hospitals. Again, it's not technically applicable to home health or hospice, but it can be a useful go by to, and we often will advise people, listen, we can't meet it, but we want to meet the spirit of it because that is generally the best way to minimize risk in any transaction where we might need something like this safe harbor to protect it. The particular safe harbor for sales of practice does put time limits on completing a transaction and on referrals post-sale between the buyer and seller. So oftentimes we'll try to build those protections into a transaction so that we come as close as we can to meeting the safe harbor. Failing to meet a safe harbor or not having one available to you doesn't necessarily mean that a transaction or the terms of it are illegal. It just means the government's going to look at all the facts of any particular situation to determine the party's intent. And what you're trying to show there is that you're not entering into the transaction primarily to, or I shouldn't say primarily, for any reason other than to exchange, fair market value between the parties for it. You're not trying to pay for referrals. Let's go to the next slide. And we've kind of covered this already. What do you do if a deal doesn't fit a safe harbor? You generally need an attorney to help you analyze it, structure appropriately to minimize your risk. And it's always good to get some kind of risk analysis done that documents what steps the parties are taking to mitigate risk. And oftentimes it can be helpful to get an appraiser involved to comment on, the transaction purchase price, and whether that reflects fair market value and is commercially reasonable, even if the parties never refer a single patient to each other after closing. That can be important ways to sort of minimize risk and protect the parties. Let's go to the next slide. So we're going to move on to sort of the important steps and documents. I'm going to cover a couple of these, and I'm going to turn it over to Les. So I mentioned letters of intent. A letter of intent is a preliminary document that lays out sort of key terms between the parties, and it's generally non-binding except for confidentiality and exclusivity. And as I said, it really sets the tone for coming negotiations. So I always encourage my clients, I like letters of intent. I think it's great to spend some time putting down on paper what the buyer's willing to offer the seller and what their expectations are. Do they expect a non-compete? Do they expect any what we call working capital? Are they going to buy your accounts receivable? That's really what working capital means. Do they expect certain key employees to stay around? Those are the kinds of terms we often see addressed in those. Let's go to the next slide. Once you've kind of gotten through that stage, you're going to move into diligence. And this is really important. Buyers, it's on you to ask the questions and to be thorough in your due diligence. And sellers, it's on you to be transparent. So generally speaking, the buyer is going to drive this process, and they're going to have a laundry list of questions. They want to learn all about your organization. I often tell sellers, if they tell me, listen, I'm thinking about selling my business. Okay, great. Let's pull out sort of the standard diligence list so that you can get prepared for this process. It's going to help you organize your information and make this process easier for a buyer. And that's not to say, you're going to spend days and days and weeks putting things together before you go to market. It's just a good way to get a head start. It also can help you identify potential issues in your business that you need to address before you go to market with something. But generally, the diligence process is really pushed and run by the buyer. They're going to look at financial statements and tax returns, liabilities, business operations, office locations, your licensure, certification, personnel, and every other aspect of the business so that they understand what it is they're potentially buying. Let's go to the next slide. Highly, highly, highly encourage buyers to do a mini claim audit. Often I encourage them to have a third party do this audit so that it's someone who's objective and isn't sort of looking for a specific result. Keep in mind, when in most of these deals, when they involve Medicare or Medicaid certified agencies, the buyer wants the Medicare and Medicaid provider agreements and PTNs. And so unless you specifically reject those agreements, you get them in a transaction by default, and you get all the successor liability that goes along with it, which means a buyer, when you take that Medicare number from a seller, you get it in all its history and all its problems. So you want to be sure you've done your homework and you understand, was this a good operator? Are there weaknesses in their medical records and in their claim history? What could the potential issues be? And often, good results are great. We like to see that. We think they're doing a pretty good job. We don't necessarily see a lot of issues, but when problems are identified, it can be, it can drive purchase price changes, hold back escrows, corrective action. It's, this is an important part in any particular transaction. Highly encourage people to get a really good expert involved. Especially if you're starting to see some issues or have questions or concerns. Big problems can lead to reductions in purchase price. I've seen them kill deals. It's very fact specific in any particular transaction. Let's go to the next slide. All right, I'm going to hand it over to Les. I think I left you about half the time, so he's going to pick up and talk about purchase agreements.
All right, so yeah, we're going to start with the main document involved in all these transactions and some of the different elements of it, and then some of the other steps or important things for healthcare transactions between there and closing. So again, the purchase agreement, that's your main agreement for every transaction. Really, no matter what kind it is, it's the binding agreement, unlike the letter of intent that sets out your price, your risk allocations, any other material provisions of the transaction. You may have dozens of other ancillary agreements, risk transfer agreements, and various other things. But this purchase agreement should detail each one of those, mention all of them. They should all be attached to it, or at least referenced. Anyway, it's going to serve as the basis for all your legal rights regarding closing, payment, penalties, liability, exposure after the transaction, and so it's got to be negotiated very carefully. It's important that you accurately reflect your full and final intentions in this because, again, like the letter of intent, it may kind of guide you on what the parties expect the transaction to look like, but this is the transaction. So there'll be, once you sign this, that's you're locked in and bound. All right, let's go to the next slide. Now the purchase agreement can look different depending on different types of sales that you're dealing with, or different types of transactions. One would be an asset sale where their buyer's just acquiring certain identified assets, properties, liabilities, that would be your computers, your licenses, things like that, but not their equity. So you end up with a new LLC, new tax ID, new owner, all that after closing. Equity sales are what they sound like. You're buying the equity in the business, whether that be a stock or membership interest, depending on if you have a company or an LLC. So technically, the owner of the business is still that same company. The only thing that really changes are who owns the business on top of that, but the provider number and all that is the same. Then you have mergers where two companies will come together. Sometimes they'll have a new entity. Sometimes one will merge and be a surviving entity, and the other one will be just consumed. That's not quite as common, other than I guess larger organizations. They'll do that oftentimes, but sometimes they'll also structure what looks like a merger as essentially an asset purchase agreement and equity sale, where the parent company ends up owning the whole other company, and they don't really dissolve anything or merge the operations together. So it's really what kind of sale you're going to be involved with could vary dramatically depending on the parties and just the particulars of that deal. In healthcare, like home health and hospices don't typically have a ton of hard assets, so most of their value is in goodwill. You're buying essentially their policies, procedures, their staffing and stuff like that. Their contracts, some contracts, not all of them, but any that you need to continue, and it will usually take assignment of the provider agreement. So you still have some of the same indemnification provisions are needed for post-transaction liabilities and things like that. So stock membership, interest sales, everything, just the legal entity, again, just stays the same. The shareholders and members are the only things that change. They'll, obviously accept an assignment of the provider agreement because it stays there all along, along with all the contracts and tax and other liabilities. So indemnification, holdbacks, things like that become a little bit more important with this kind of a sale, or at least you have a wider range of liabilities that can occur. Mergers, very similar to a stock or interest sale, but except usually someone lots of times is going to remain an owner in part. So some of the provisions could be slightly different if they are remaining on as a partial owner of the merged entity, because you may not have a complete purchase, I guess, of all interest. They may hold back some. Let's go to the next slide. Next slide. All right, so generally, whenever when you're looking at the purchase price, it can be, all up front, or it can be over time. Lots of times there's going to be some kind of a holdback involved with the purchase price. So they'll generally range from 10 to 25%, and it all kind of depends on the risks associated with that seller's business. If during due diligence they find out that there's been a lot of major negative overpayment findings from audits, or any other kind of disciplinary things that have gone on and this organization has just gotten out of, or they've just gotten out of a, say, corporate integrity agreement, you may want a larger holdback because you'll just figure there'll be greater risks for the buyer. But rather than just allowing the buyer to pay less money, it's better to get a formal escrow account and an agreement set up so that basically they pay the money into that, and any disputes have to be handled with a third party actually controlling the funds. Some sellers will be willing to do owner financing. I say that a lot more these days with small, like nursing home sales and individual home health sales. But larger organizations aren't going to do that as much. But they'll allow the buyer to pay, down payment with structured payments over time with a promissory note securing it. I think we're a slide behind still, Gio. just like one
That's
behind
good.
actually. Anyway,
Oh, that's
purchase
good.
price
Okay.
adjustments at closings are common. They pay the debts of the seller. They'll pay transaction costs of the seller. And one good thing is, if you have adjustments, you can end up with some additional work and capital for the buyer. We'll go to the next one. One of the most important and kind of, I guess, sometimes dangerous areas of the purchase agreement of the reps and warranties areas. Sometimes you'll have these as a different schedule attachment to it, but essentially these are the promises that both buyers and seller are saying. So obviously they're both warranting that they have the authority to enter into the transaction, and that buyer's going to provide the funds, blah blah blah. They'll also have some specific, I guess, exceptions or facts tied to the reps and warranties, so they can be quite detailed. And you'll basically just the seller's going to try to disclose everything that they know and not go too far. So saying that you've a warranty that you've complied with all laws without any kind of a materiality provision or anything like that could be problematic, because in healthcare sometimes it's impossible to comply with every law all the time, with every single note that's produced. So you want generally to have some good eyes on all of this language in the reps and warranties. But any material inaccuracy is going to be grounds for them to sue or seek indemnification. And you're giving them, if you violate a rep or warranty, you're giving them one of the easier ways to go about doing that. But common examples are, the financial reports are accurate and complete, no litigation or audits are pending, the business has complied with all applicable laws within reason. Go to the next slide. We'll look at some healthcare specific ones. These are almost always in every healthcare transaction. The seller's going to warrant that they have or represent they have all licenses, certifications, and contracts necessary to operate, and they're all in good standing. They're going to certify that they're enrolled in Medicare, Medicaid, and those enrollments are active, that they're not subject to any disciplinary or corrective actions or appeals, or you'll disclose them. And just, sometimes you have to give a big detailed disclosure about, say, if there's a pending audit, you'll just disclose essentially what the audit involves, what the potential total liability is, and things like that. And that may impact, say, holdback. But you wouldn't want your reps and warranties to, if you just got a canned contract from somewhere else that was using some other contract, and it says that you have no, outstanding overpayments or audits going on, and there actually are, well, then you've got a violation of your reps and warranties and potential issues. You may have a seller or rep that they've conducted all their exclusion screening and any other kind of mandatory rules, and that none of their employees are excluded from participating in Medicare. You definitely want to get paid. If there's no claims or enforcement actions still pending, audits, investigations, and in home health and hospice, you're always going to have something that's going to have something to do with the 36-month rule, saying that there hasn't been a change of ownership in the last 36 months or any other kind of restructuring that would trigger that rule. Let's go to the next page. So you may see indemnification provisions in, every kind of contract imaginable almost these days, but in buy-sell agreements involving, say, home health and hospice, you're going to see them really in all of them, but they're going to be, I think more important really in, say, an equity agreement. You've already contractually taken care of most of the pre-transactional liabilities in an asset purchase, because you're just not going to purchase those, but you're still going to put an indemnification provision in the agreement anyway, in case someone sues you instead. You don't know all the different ways you may end up losing money because of something, so you just put this in there anyway. But it's a little more important with the equity purchases. But they're basically agreeing to compensate and hold them to harm the buyer for any problems that arise in the business from the seller's actions, breaches of warranties, or claims by third parties related to pre-sale periods. Post-sale periods are on them. Consider escrowing a portion of the purchase price to cover indemnification for a defined period of time. So you can kind of look at what your potential liabilities are, if you know of any possible things out there like outstanding audits, and come up with a figure that's somewhat reasonable and acceptable, obviously, to both parties. So let's go to the next slide. Qualifications, exceptions. So again, you may be saying that you're not aware of any other any overpayments or sanctions or anything like that, but you may know that you've received a letter requesting records or just inquiring about something. So you may qualify that earlier statement with some exception or qualification to your reps and warranties. You can also use these to limit your indemnification provisions and things like that to particular levels or even lines of business on occasion. But you'll want to make sure there's a materiality requirement on anything that's a promise that you're swearing that you've done all this. Any particular list of things, you want to make sure that if there's a slight deviation from that, that's not material, it doesn't impact anything. With indemnification, you're always going to have a time limit on what's reasonable. So, with if there's fraud or criminality, things can go back much farther, but you may have just 6 years for I think False Claims Act deals, and the reopening provisions may limit audit risks after a certain period of time. So all of those different things, I guess, depending on the kinds of business you're in, or if you've got cost reports that you file, things can be different. Your timeline's going to be different because of that. So you'll take into account, I guess, your specific statute limitation and when you're determining what levels of indemnification are needed. So all these are very negotiable. They're going to be very fact specific, but this is where you want to clean up your reps and warranties or your indemnification provisions or anything else. You just really want to make sure that nothing is overpromised, I guess. And where necessary, if you're indemnifying someone else, you want to limit that exposure for yourself as much as you can. So let's go to the next page. So closings. Sometimes it's the same day as the purchase agreement. Obviously, sometimes it can occur later. We may have the purchase agreement signed, but we're still waiting on all the CHOW application stuff to be approved, or any other regulatory kind of approval to be issued by the state. And that may just be a closing condition that we require before the final purchase price is paid. The conditions closing is some of your most important rules that you're going to put in there. These are your drop dead. We do not proceed if this doesn't happen. Obviously, if someone's buying a healthcare business and if they want the license and they're paying to accept provider agreement and all that, they're going to want to make sure that license is still there. So that has to be an actual valid license. That'd be a condition of closing. Providing the funds, right, for the purchaser, that'd be a condition of closing. Those are obviously the simple ones, but there's obviously, with healthcare transactions, there's going to be several others in here. Also, sometimes when your closing is really drawn out, you may have significant amount of costs that are incurred or work that is going to be performed between signing a purchase agreement and actual closing. So in that case, you may want to include the non-refundable deposits, or like a liquidated damages clause that would, require the buyer to forfeit, a certain amount of funds if they don't proceed with the transaction, or if they just back out. Even if it's, otherwise not a breach of the contract. So let's see, let's go to the next page. All right, at closing, parties reveal the documents, agree to any necessary additions or revisions. There's always something that gets added the last day. They're waiting on some piece of information, but officially transfer the ownership of the assets and equity and transfer the purchase funds. It's just really simple. That it's not a whole lot different than closings in a residential real estate situation. Literally everyone's sitting at the table signing documents. It's or DocuSign these days lots of times. But if it's a big transaction, they're going to be face to face. Most of my clients have. So after the closing, we still may have a lot of dealings with each other. There may be a transition period where the seller stays on, or some of the seller's staff stays on for some period of time, and that'll assist in retaining employees and patients and just keeping more or less giving training or just a transition period for the new owner. There's always a million things to explain, obviously. I've seen this done two ways. I've seen where just it's part of the contract and essentially part of the purchase price or sales price is the buyer is paying the seller to stick around for 6 months or 8 months or whatever and help with transition work. And I've seen it where they instead just agree to pay them X dollars per month. And that's far better. Every time I've had them where it's a one payment up front, and there's not going to be ongoing payments for each month of work, they end up not working and not doing anything to help. They figure they've gotten all their money and they leave. So just a pro tip, definitely don't just make that an upfront payment. The goal of the seller in the situation is to minimize their exposure from liability and from claims made by the buyer. Basically just make sure that everything goes smoothly, because buyers more likely to get upset when things go poorly, obviously. So any sticking around for some period of transitional, time period is helpful, I think, in every transaction. The buyer commercially is now running the business, so they're worried about anything that you haven't disclosed or whatever. So they're going to want you around just to fix things immediately. Some transactions will have deferred payments, but they'll rely on each other to comply with all that. So you really want to make sure that there's not, escrow accounts are better for anything that's going to be a large amount of money paid to either party, well after, closing. Everything else can end up in litigation, or someone can just not turn over, not cut a check and force you to sue them in order to enforce that. And lots of times people won't. So I would definitely do escrow for every bit of that you can, unless it's very small amounts of money. After the close, let's go to the next slide. So after the closing, lots of deals will include things called restrictive covenants, where they may have non-competition agreements or non-solicitation covenants. Those will protect the buyers. And then you may have covenants concerning their business and employees, terminations, pay, or severance, just promises not to disclose any information from the seller's time period of operating and things like that. Very common, subject to dispute, because lots of people ask for a million different things in here and just outlandish, time periods, but it's regardless of what the parties really want. Usually lots of times these things are covered by very specific laws that restrict them and their scope by geography, time, and kind of, market or practice area. And in some cases, it's much easier to enforce a restrictive covenant against a business than it is a person. So all of these little issues have to be kind of dealt with, and it's a rapidly changing area, actually. So this is another area where you really need a lawyer to look at it. Not only may your provision not be enforceable, but you might actually, get in trouble in some way. So let's go to the next slide. All right. So after closings, home health hospice deals usually involve post-closing purchase price adjustments based on updated valuations. When you turn over the closing process is so long. Lots of times when you've turned in your all your prior 3-year financials and trailing 12-month financials, they'll make an offer that's based on a multiple of EBITDA, like Jennifer was saying. And if that has changed from that point of that offer until closing, they may have a provision that's already in the contract that would adjust that purchase price by some amount. This is very common. Purchase agreement also needs to define how AR will be split, and that needs to be very, very specific. This is in every transaction typically, and it's always an issue. Either one side's not trusting the other side, to turn over funds, or there's a big disagreement about how they're split. Usually there's, it depends on who's going to be billing and collecting the stuff. If it's funds that have already been billed, then obviously there's no need to pay or give any amount to the buyer for that. But if they're going to be collecting it, they're going to probably want, some payment for that, or there'll be a discount on what they'll pay you for what they do collect. And that'll usually change over time, whether it's, 30-day out AR versus 120-day out AR, things like that. And then sometimes they'll just say every dollar for everything before the closing, before transit closing belongs to the seller. Everything after belongs to the buyer. But then you have a buyer usually who's running around trying to collect funds if they're not getting paid any money to do it. So they don't do it they're not as, thorough with their attempts, and you'll end up not collecting as much anyway. So AR definitely has to be dealt with specifically and everything. They'll also want price adjustments to discourage sellers from letting the business fall apart during the transactions. This is basically if your EBITDA is dropping dramatically or your census is dropping dramatically, there may be provisions in there that would adjust slightly the purchase price, usually not by giant amounts. It's not like it's going to half it, but maybe a 5% swing, or maybe a swing that's commensurate with the amount change in EBITDA. Also, you need to follow your Medicare, Medicaid change information immediately. You have 30 days to do it, but get on top of this. There's so many people you have to notify. You just need to start that whole process and have a real organized list of all the things and contracts and MCOs and other people that you have to identify, notify, and whether you have. It can get confusing on remembering which of the various entities and agencies and whoever that you have to notify. It's really too many of them. But let's see. Let's go to the next slide. Special issues for home health and hospice. So 36-month rule. So this, again, we talked about this earlier, limits direct changes in majority ownership with no more than every 36 months. So obviously during these transactions, you're going to make sure that this hasn't happened. Sometimes you'll find a home health that or hospice that is subject to this rule, but we want to move forward with something anyway. You can, in that case, you can end up getting a management agreement for the buyer so they can manage it essentially over until the 36-month restriction is out, or just until closing happens. You may have a management agreement regardless of the 36-month rule, actually. But regardless, have the management agreement be part of the deal and drafted by an attorney. There are some exceptions too, so it's not like every single time you see a change in ownership, you'll have the 36-month rule apply. Like if it's due to death or corporate reorganization, it doesn't apply. If you can get off a little early if the business has submitted 2 full cost reports since the last, since their initial enrollment or the last change of ownership. And it also doesn't apply to indirect changes of ownership. So if you're about to start a home health or hospice, you could structure it in a way that can make it less likely that you would ever run into a 36-month rule issue, even if you are selling things, because it doesn't apply to indirect changes in ownership. So a few other issues. Hospices, again, with an asset sale or 100% equity sale in Arizona, California, Nevada, and Texas are subject to enhanced oversight. I'm surprised Florida and Louisiana aren't in there. We always are in the enhanced everything usually, but luckily we're not yet. So that's prepayment review for 30 days to a year. Would not be fun to go through. Make sure that you're reviewing all the payer contract assignments and notice provisions carefully. Lots of times you can mess this up. Every little MCO, and so it's not just Medicaid or Medicare, whoever you have to deal with. It's each of the little managed care organizations under them and each little payer. They could have provisions in that let them kind of screw around with you if you haven't gotten all your people re-credentialed, or maybe the buyer's bringing on some new staff and they haven't done that. You want to do all that at the same time. Get any new staff credentialed at the same time that you're informing them of any change of ownership. So obviously you're going to want to look through what staff you're going to retain. You're always going to retain people. Leadership, some of leadership may up top may be replaced, but whoever's putting patients in beds probably needs to stay. Don't forget about your accrediting body. So if you're CAR for JCO accredited, you'll need to notify them and review all their documents. That's really what you're buying. If you're buying a home health or a hospice that doesn't have, unless it has its own building, you're buying their policies, the paper behind their business really, and all their contracts. So look through all of them and know what you've got, what you need to fix immediately, what you need to just improve on, anything you want to change. But mainly you're looking for red flags and real big problems. Perhaps they've not been getting, I don't know, some particular form that's supposed to be signed within 36 hours of admission. Maybe they've been doing that every single time at 48 hours. You want to know that because you may lose a day or two of reimbursement, for every single stay. Consider cost saving strategies that can be realized in the transaction, such as obviously the buyer's got, other locations that may be able to remove some redundancies and streamline their administrative systems. And I think we're getting to the end. Let's go to the conclusion. Next page. So basically, I think what we're both trying to get across today is that these are really complex, and there's a million different things you really need to look through. It can take a while, so it takes a lot of planning and expertise, and it frankly it doesn't come just from us healthcare lawyers. We're having to rely a lot on sometimes healthcare specific CPAs or valuation analysts and others to just make it through these little transactions. So definitely, it's not something that you just want to do with a handshake. You make the deal with a handshake. You write down essentially the deals on the details on a napkin, or basically your letter of intent. But everything from that point forward has to be perfect. And really, it should be as near to perfect as possible before the purchase agreement. But it's all pretty serious stuff, and it can cost you a lot of money if you do it wrong. So hire the right people, invest the money if you're going to sell or buy a home health or hospice. I guess we can turn it over for questions since we've hit the end.
Yeah, thanks, Les. So we're happy to answer any questions now. If anybody wants to type something in the chat box, we're also, of course, available after this ends. Our contact information is on this last slide. You're welcome to email or call. I will say email probably is easier for me. I don't know what Les prefers, but we're happy to chat with folks afterwards if you've got specific questions.
Yeah, that's my cell, so you can reach me anywhere in the world on that. I probably shouldn't put that.
That's actually my cell number. That's actually my cell/work number also. So
awesome.
It's direct to me as well. Gio, do you see any questions?
No, there's no questions.
All right. Well, thank you everybody for joining us today, and we look forward to our next presentation with the Home Care Association of Louisiana. Thank you.
I'll be sending the PowerPoint slides tomorrow, so if you have any further questions like Jennifer say, please reach out to Jennifer and Les. And have a great Tuesday. Anything to say, Les?
Nope, I'm good. Y'all have a good day. Thanks.
Have a good day, y'all.